For those of you who do not know me, my name is Dana Haney, and I'm the director of the Criminal Justice Research Center and a professor of sociology here at OSU. It is my pleasure to welcome you to CJRC's 2016 Excellence in Justice Seminar, featuring Professor Barry Feld, with comments by Professor Ryan King and Linda James, the Assistant Director of the Ohio Department of Youth Services. For those of you who are joining us for the first time, the Excellence in Justice Seminar is a symposium that was started as part of a partnership between CJRC and the Ohio Department of Rehabilitation and Correction. Our idea is to combine the research power of CJRC with the policy expertise of what is now ODRC's Office of Offender Reentry to translate research into evidence-based best practices. With that as an introduction to the series, I would like to turn now and provide very brief introductions of our fantastic speaker and panelists. Professor Feld is one of the nation's leading scholars in juvenile justice. He is a graduate of the University of Minnesota Law School and holds a PhD in sociology from Harvard. He currently teaches criminal procedure, juvenile law, and torts at the University of Minnesota. In 1990, Professor Feld was named the law school's first centennial professor of law. He has served in many professional capacities over his career, including as a member of Minnesota's Department of Corrections, Special Committee on Serious Juvenile Offenders, on the Hennepin County Juvenile Justice Task Force, the Minnesota Supreme Court Advisory Committee on Legal Representation of Juveniles, the Minnesota Juvenile Justice Task Force, as a co-reporter for Minnesota Supreme Court's Juvenile Court Rules Advisory Committee, and the American Bar Association's Juvenile Justice Due Process Advisory Board. Professor Feld is a member of the American Law Institute and a fellow of the American Society of Criminology. In 2008, he received the American Bar Association's Livingston Hall Award, which recognizes lawyers practicing in the juvenile delinquency field who have demonstrated a high degree of skill, commitment, and professionalism in representing their young clients. Professor Feld has written more than 10 books and too many articles to count. Today he's going to discuss his recent book, Kids, Cops, and Confessions Inside the Interrogation Room. This book received the 2015 Outstanding Book Award from the Academy of Criminal Justice Sciences and cited as an extraordinary contribution to the study of crime and criminal justice. And I could not agree more. We are very honored and excited that he can join us today to continue his dialogue on this very important work. We are also very pleased to welcome Professor Ryan King, who is serving as a panelist. Ryan is an associate professor of sociology at Ohio State, whose research focuses on law, criminology, and intergroup conflict. He has written 2 books and published numerous articles in the top-rated sociology and criminology journal outlets. Current research projects investigate the cause of hate crime, the effects of parental incarceration on child well-being, the criminal sentencing and deportation of non-citizens, the relationship between hate crime and terrorism, and the association between skin hue and criminal sentencing. Joining Ryan as a panelist is Linda James, the Assistant Director of Ohio's Department of Youth Services, which serves as the juvenile corrections system for the state of Ohio. Linda has worked in the criminal justice world for more than 29 years, including spending time as a caseworker and trainer at a halfway house and a county probation officer. She has held several different positions in the Ohio Department of Rehabilitation and Corrections, including as a parole officer, an administrator in the Recovery Services area, chief of the Bureau of Community Sanctions, and deputy director of the Parole and Community Services Divisions. Prior to joining DYS in 2013, she served as the assistant director of the Ohio Department of Rehabilitation and Corrections. Linda's focus in the Department of Youth Services has been to improve safety, evidence-based best practices, and enhancing youth treatment. Okay, so in terms of the structure of today's lecture, during the lecture, Professor Feld will speak for about 40 minutes. Following this, our 2 panelists will provide some very brief comments, taking about 5 minutes each, and then we'll open it up for questions. Okay, as I mentioned, please continue to help yourself to lunch as we go through the talk. Thank you.
Thank you, Dana. I'm really delighted to be here today to talk about police interrogation of juveniles. The Supreme Court has decided more cases involving interrogation of juveniles than any other aspect of juvenile justice administration. And on the one hand, the court tells us that youths are vulnerable and their immaturity makes them especially susceptible to false confessions and the like. But on the other hand, the court says we're not going to give kids any special procedural safeguards. We're going to treat them just like adults, and we will use the same standard, knowing, intelligent, voluntary, under the totality of the circumstances, to evaluate juveniles' waivers as we use to evaluate adults' waivers of their Miranda rights. At the same time, developmental psychologists have been looking at kids for several generations. And they question whether kids have the cognitive ability or the maturity and judgment to make these kinds of knowing, intelligent, and voluntary waivers. And especially for kids 15 and younger, the developmental psych research suggests that their immaturity makes them almost incapable of meeting this adult legal standard. And we see that also reflected in the disproportionate overrepresentation of juveniles among the population of people who give false confessions. And on the other hand, the psychological research suggests that 16 and 17-year-old kids pretty much are functioning on the same level as adults in terms of their cognitive abilities. So my talk today is based on the book that Kids, Cops, Confessions Inside the Interrogation Room. You can get it from Amazon. You can get it from NYU Press. It's really terrific. I mean, it's pretty good. So my talk today is going to be broken into 5 parts. First, I'm just going to talk about the legal framework and the developmental psychology as it relates to the legal framework. Second, I'm going to talk a little bit about interrogation, because interrogation is one of the most important components of the criminal justice system and the juvenile justice system, and yet we know almost nothing about what happens in the interrogation room. I'll spend a little time talking about the data I collected in Minnesota and analyzed. This involves felony interrogations of 307 16 and 17-year-old juveniles, and I will focus on how kids waive their rights, how police question the kids after they waive their rights, and then how the kids respond to the police officers. And finally, I'll talk about the policy implications, because given how little we know about interrogation, there are a number of important policies that I think follow from this. In your handout, on the first page, you have your Miranda primer. And as I said, the Supreme Court has decided more cases involving juveniles. And in the early days, in Haley v. Ohio, they dealt with a 15-year-old. In Gallegos v. Colorado, they dealt with a 14-year-old. And the court, in those cases, said, youthfulness and immaturity can render statements from kids involuntary. In Ray Galt, the Supreme Court gave juveniles the Fifth Amendment privilege against self-incrimination, and in the case of a 15-year-old, also sort of brought the Miranda framework into the juvenile justice business. In Fair versus Michael C., the court dealt with the interrogation of a 16-year-old and essentially said, we're going to treat kids just like adults. We're going to use the same legal standard, knowing, intelligent, voluntary. And the court said we don't need any special procedures to protect kids. And in JDB versus North Carolina, the court dealt with a 13-year-old, and the question there was whether or not this kid was in custody at the time police were questioning him for purposes of whether or not he should have received his Miranda warning. Minnesota follows the majority law, which is we're going to use the adult standard, knowing, intelligent, and the voluntary. And we treat kids just like adults in the interrogation room. So the question then becomes, when we're looking at the validity of a juvenile's waiver, courts will look at characteristics of offenders, their age, their IQ, their prior experience, their education level, their age, and things like that. And they also look at the context of the interrogation. Where did it take place? How long did it go on? What kinds of tactics were used? There are a few states that require a parent to be present during a kid's interrogation because they think that somehow parents can provide the kind of decision-making competence and protection that kids lack. At the same time, as the Supreme Court and state law says we're going to treat kids just like adults, the developmental psychologists have been contending for several decades now, kids are not adults. They don't have the cognitive ability of adults, they don't have the judgment of adults. Then on the one hand, kids 16 and older have about the same cognitive ability. That is to say, they can understand words. And to the extent that they can understand words, there's a body of research coming out of the informed consent medical decision-making literature, that says 16-year-olds, 17-year-olds, they're really sort of tracking adult decisions. But we have come to learn that the kinds of decisions people make in a laboratory under total information and cold cognition is very different from the kinds of decisions kids make under stress. And the interrogation room is a very stressful, a deliberately stressful environment. And so for the last couple of decades, the MacArthur Foundation has been sponsoring research on adolescent competence to make various kinds of legal decisions. And that research suggests that on the one hand, kids can understand words, older adolescents can understand words about the same as do adults, but they differ qualitatively in their judgment, in their maturity of decision making. And the emphasis both in the MacArthur research and as it has been translated into law is that they're immature, they're impulsive, they make poor decisions, they calculate risk differently, they emphasize short-term gains over long-term consequences, gains like I want to get out of the interrogation room, as opposed to the consequences. And all of the developmental psychological research is also bolstered by all the neuroscience, that also suggests kids' brains are immature and they're more impulsive and they lack the kind of self-control. When developmental psychologists have looked specifically in the context of interrogation, what they point out is that, especially for the younger kids, they just don't understand the words. I mean, and especially for the younger ones, just the words in the Miranda warning are just beyond their intellectual capacity. And even if they understand the words, they may not understand the concept. Things like telling a kid you have a right. Kids grow up having no rights. Telling a kid you can waive your right to counsel. Kids have no idea what waive means other than that way. So lots of the concepts embedded in the Miranda warning itself are already beyond the comprehension of many adolescents and especially the younger kids. And jurisdictions that have experimented with dumbed down Miranda warning, dumbed down for kids, find that in fact the warnings are longer and they're more difficult to understand than the straight Miranda card itself. Tom Grisso has done most of the research, laboratory social psych research looking at kids, and he reports that especially for kids 15 and younger, half of them misunderstand at least one of the 4 components of the Miranda warning, and even the older kids, about a quarter of them, don't get it. They both don't understand the words, and they especially don't understand the concepts involved in the interrogation process or the significance of rights. And in another line of research, the developmental psychologists are also looking at kids' adjudicative competence, their competence to stand trial. And competence to stand trial also focuses on, do you understand the proceedings? Can you make rational decisions? Can you assist counsel? And again, the research is very clear that by the time, for kids 15 and younger, there's a very sharp drop-off in their competence. And the Supreme Court has emphasized in Roper and Graham and Miller, where the Supreme Court abolished the death penalty and life without parole for non-homicide and mandatory life without parole for homicide, the court kept emphasizing the fact that kids' judgment, immaturity, impulsivity makes them less culpable than adults. But Roper and Graham and Miller also emphasized the fact that kids are susceptible to social influences to a greater extent than adults. And the interrogation room is an instrument of social influence. It is designed the court described it as the inherent compulsion of custodial interrogation. It creates various kinds of pressures. And part of it is that children are going to be more susceptible to those kinds of pressures, more inclined to obey authority, and to acquiesce to the negative pressures that interrogation is designed to create. So there's a basic disconnect between what the law says about kids and what developmental psychologists and, as the Supreme Court has as every parent knows, kids are not adults. So I'm going to talk a little bit about interrogation. And in talking about interrogation, when the Supreme Court decided Miranda, it was deciding Miranda in a vacuum. We had absolutely no empirical research of what happened. And so the Supreme Court had to rely on interrogation manuals as a proxy for what actually happens in the interrogation room. And the court relied especially on Inbow and Reed's criminal investigation and interrogation. That's a Reed, R-E-I-D, John Reed, because I'm going to be referring to the Reed method, which is the way most police in the U.S. were trained then and are trained now to interrogate suspects. And the Reed method recommends both isolation, to cut off any kinds of external or social supports, and various kinds of psychological manipulations, maximization tactics and minimization tactics. And maximization tactics are designed to overcome resistance and to sort of create pressures to confess. And minimization tactics are designed to neutralize guilt and make it easier for people to confess. I'll just sort of, maximization tactics convey the interrogator's rock-solid belief that the suspect is guilty and all denials will fail. Such tactics include making an accusation, overriding objections, and citing evidence real or manufactured to shift the suspect's mental state from confident to helpless. Minimization, because I'm going to be coming back to these, minimization tactics provide the suspect with moral justifications and face-saving excuses for having committed the crime in question. Using this approach, the interrogator offers sympathy and understanding, normalizes and minimizes the crime. And Reed training also says, just like the law, we're going to question kids just like adults. The Reed book says, the principles discussed with respect to adult suspects are just as applicable for use with younger ones. And it's important to note that Reed training is confrontational, it's accusatory, it's designed to elicit a confession. And we can contrast that with the kind of interview practices that are used in the United Kingdom. Because for the last 20 years, as a result of some false confessions obtained from IRA suspects, the UK has required police to record all interrogations. And as a result, the police, in consultation with psychologists and lawyers and others, have developed a softer kind of interrogation practice. It's called investigative interviewing. And investigative interviewing isn't designed to elicit a confession. It's designed to find out what happened. We're just trying to find out, what happened in a particular instance. And as I say, the UK has been recording interrogations for a couple of decades, and I'm going to be referring to some of their work as well. When I say there's been remarkably little research on interrogation, that's an understatement. When the Supreme Court decided Miranda, there was a little research in the late 60s just to see are police actually giving Miranda warnings, and what is the impact of giving a Miranda warning on suspects' willingness to talk. There was one study conducted in 1967, the Yale New Haven study, where they actually sat in the interrogation rooms, and that was the first ever empirical study of what happens when police question adult suspects. In the mid-1990s, Richard Leo sat in on 116 interrogations in Oakland, and that was the second ever empirical study of what happens in the interrogation room. For the last decade, I have been analyzing interrogation tapes and transcripts, and reporting various articles and book about the process. There's a lot of research coming out of the UK because they have had the benefit of recorded interviews for several decades. Social psychologists have been studying interrogation, and Saul Kassin is the leading researcher in that area, but the validity of what goes on under IRB constraints in a laboratory is very different from what goes on at the police station. And finally, a lot of what we know about interrogation comes from those relatively few cases of false confessions, because they also help us identify some of the characteristics, and especially problematic characteristics of interrogation. So in Minnesota, as I said earlier, we use the adult standard, knowing, intelligent, and voluntary. And in 1994, the Minnesota Supreme Court required police to record all custodial interrogations. It's also the case in Minnesota that 16 and 17-year-old felony cases are public proceedings. And so I thought, well, okay, I just called up my friendly county attorneys, all of them were former students, and I said, I would like complete unrestricted access to your files, and they said, sure, Barry. It was a really extraordinary research access. So I had 2 urban counties, Hennepin and Ramsey, which is Minneapolis and St. Paul, and 2 suburban counties. And basically they generated a list of every 16, 17-year-old kid charged with a felony. And then we just went through all of those files, and every time we found a tape or a transcript or a police report that said a kid invoked their Miranda rights, we just copied the file. We copied the police reports, the juvenile court reports, the sentencing reports. And so I ended up with 307 felony interrogations of 16 and 17-year-olds. And when I had these files, this was a very labor-intensive project in which I first would read the file and the police reports because I wanted to know what the police knew at the time they conducted their interrogation. And then secondly, I coded the files simply to I know who was there, when did it take place, where did it take place, how did they warn the kid, how did they question the kid, how did the kids respond, how did whether or not a kid invoked or waived their Miranda rights affect case processing. But I just wanted to know, what is the impact of interrogation on the whole process of juvenile justice administration? So I ended up with, this is the largest N in criminology. It represents the work of 150 police officers in 50 different departments questioning these kids. And then after I had gotten all of the quantitative data, I interviewed more than 36 police officers, prosecutors, defense lawyers, and judges to sort of learn from them what I was finding and to bounce my findings off of them to make sure I got it right, because I told them, I'm trying to tell your story and I want to make sure I get it right. So I'm going to tell their story now. I'm going to focus on kids' waivers or invocations of their Miranda rights, the interrogation tactics the police used, and the length and outcome of questioning. In your handout, the first table simply describes the characteristics of the kids in this sample of 307. Obviously, they're almost all male. Half of them are charged with property crimes, a third with violent crimes. A little over half of them were charged with 1 felony, a little more than a quarter were charged with 2 or more felonies. I don't have the most serious juveniles because those are the kids who get transferred to criminal court. So this is sort of the routine deep-end felony docket of juvenile courts. About a third of the kids had no priors. A quarter of them had 1 or more prior felony arrests. Half of them had been referred to juvenile courts previously. Half were white, a third were black, and the rest were kids of other backgrounds. And this sample is a little more serious than what the routine felony dockets of these counties courts look like. So it's a good deep-end juvenile population. The Supreme Court in Miranda said anytime somebody is in custody and subject to interrogation, you need to give them the Miranda warning. Almost 90% of these kids had been formally arrested at the time they were questioned. Almost 2/3 of them were placed in detention following their interrogation. Interestingly, about 10% of the questioning took place in squad cars, and other questioning took place at kids' homes or at kids' schools. Those school resource officers are another problem for kids. So the first thing is, okay, so we've got these kids, how do police give them the Miranda warning? And the Miranda warning is really sort of problematic for police because on the one hand they have to tell suspects they have rights, but on the other hand police have absolutely no incentive for suspects to invoke their rights. You know, so they're caught in this kind of problem. Well, I got to tell you, but I'm going to tell you in a way that's not going to tell you. And so when a suspect is brought into the interrogation room, in about half the cases, as soon as the police identify who the kid is, they'll give them the Miranda warning. And in the other half of the cases, they'll sort of go through booking questions. You know, how old are you, where do you live, where do you go to school, as a way to kind of socialize kids to talking and to answering police. But police are going to predispose kids to waive their rights. They'll minimize the warning, they'll embed it in the conversation, they'll describe it to kids. This is an administrative formality. If a kid has to sign a waiver form, that's another way of turning the Miranda warning into a bureaucratic process. They may tell the kids a little bit about the evidence they have before they ask them whether or not they want to waive their rights, and they'll tell them, well, you know, this is your opportunity to tell your story. Tell your story is a recurring theme of the way in which police are talking to the kids. And then once they've gone through the formality of giving the Miranda warning, the kid has to make the decision, the knowing, intelligent, voluntary decision, whether or not to waive or to invoke their rights. And in this case, each time the police would read the kid their warning, you know, you have the right to remain silent. Do you understand that? If the kid says yes, that is a knowing and intelligent waiver of their rights. And so they go through each, do you understand that? Yes. And after we've gone through that process, bearing in mind that I'm a police officer and I've just read you your rights, are you willing to talk to me about this matter? And if the kid says yes, they have waived their Miranda rights. They have waived their only legal protection in the interrogation room. Now, when the Supreme Court decided Miranda, Justice White, in his Miranda dissent, said, if custodial interrogation is inherently coercive, why is not a waiver of your Miranda rights just as coerced as an unwarned statement would be? And Justice White was right. More than 80% of adults who receive their Miranda rights waive their Miranda rights, waive their only protection in the interrogation room. And 90% or more of kids waive their Miranda rights. You know, I attribute the difference between kids' waivers and adults' waivers to the fact that kids have less understanding, they are less able to exercise their rights given the power differential between adults and kids. They have less prior experience. So in Table 2, I report that in this study, 92.8% of all the kids who received the Miranda warning waived their rights. And I asked the cops, you know, how many kids waived their rights? And, you know, there was an amazing consistency. They'd say, I'd have to say 95% or more. I'd say 95. I'd say high 90s. All of the cops, you know, 90% or more of the kids are waiving their rights, and none of them suggested, you know, less than 80%. So there was, you know, my 92.8, you know, I sort of hit it right on the nail, at least in terms of what the police were corroborating for me. When the Supreme Court decided Fair versus Michael C., one of the things that the court emphasized was that he had prior experience with the justice system. And it turns out there's only one variable that influences suspects' invocation or waiver of their rights, and that is whether or not they have a prior felony arrest. Both for adults and juveniles, prior felony arrests, those with prior felony arrests are significantly more likely to invoke their Miranda rights than those without. And so as I was describing this to the police, they were, you know, I said, well, who are the kids who invoke their rights? And the cops said, you know, they're the savvy, sophisticated, streetwise, and they agreed with me that a prior felony arrest is a good proxy for savvy, sophisticated, and streetwise. They, you know, the kids have had a learning experience. They confessed the last time and it redounded to their disadvantage. Or they have met with an attorney on their last felony and they learned something from their lawyers. Or just having been questioned about a felony previously, they've learned to resist the pressures of the interrogation room. So next I looked at, of the 285 kids who waived their rights, how did the police question them. And police question suspects for lots of reasons. They want to get a confession, they want to get an admission, but they also want to get leads to other evidence. They want to be able to give the prosecutor statements with which to control witnesses or to impeach their testimony if they take the trial. And so in many of the interrogations, the police would come into, and when they'd start questioning, they would describe themselves as dispassionate report writers. I'm just here to take a statement. I'm just here to write a report. This is your opportunity to tell your side of the story. You know, I've already heard the other side. All I'm basically just going to be a secretary writing down what you say and passing it on to the prosecutors and to the judges. But they also use various tactics to encourage people. The maximization tactics in Table 3, describe some of the maximization that are really designed to intimidate, to emphasize the futility of denials. They'll overstate the seriousness of the crime. And so, in terms of the maximization tactics, this is sort of where the real coercive pressures are coming in. They will confront kids with evidence. In more than half the cases, the police would refer to some kinds of evidence that they had to sort of put pressure on the kid. In about a third of the cases, they would accuse the kids of lying or encourage them to tell the truth. So the Table 3 just sort of describes the categories of tactics police use. Significantly, in a third of the cases, they did not use any maximization tactics at all. In another quarter of the cases, they only used one tactic. And in only less than a third of the cases did they use 3 or more tactics. And it just takes a single question to count as a tactic. So that, part of what I drew from this is police didn't really have to lean very hard on these kids. They don't require much persuasion in order to talk. In the cases in which they were using these maximization tactics, they would most typically confront them with evidence, with physical evidence, with witness statements, with their co-defendants, because kids commit crimes in groups, and so cops will be interrogating kids, several kids from the same crime in different rooms simultaneously and whipsawing them back and forth. So they were using these various tactics as a way of getting the kids to either, make some kind of incriminating statement. And then the cops would also sort of reinforce their roles as report writers. And so they would tell the kid, I'm just going to pass on whatever you tell me to the prosecutors and the judges. And the judge is going to look at you and this is a really implausible story. And judges don't like kids who lie, so you might as well tell the truth. And on the other hand, they will look more favorably on people who do tell the truth. When they would tell the kid, this is your opportunity to tell your story, it's a time-limited opportunity. The cops would say, once I leave the room, I'm just going to pass the report on with all of the nonsense you've told me already. So this is, and also this time-limited, I referred earlier to the fact that kids commit crimes in groups, and so they're always telling the kid, the other guys are trying to say that you were the one behind it all, so they're always trying to shift responsibility, and that provides another kind of impetus for each kid to try to make the best deal that they can. In addition to the use of these maximization tactics, they also use minimization tactics, although to a much less extent. And minimization tactics, in criminology, Sykes and Matza introduced us to techniques of neutralization, right? In the delinquency theory, how do kids free themselves up to engage in delinquency? And you can think about these minimization tactics as similar to these techniques of neutralization. Importantly, police don't use minimization tactics nearly as frequently as they use maximization tactics. When I say minimization tactic, that's the kind of thing you say to a person you're interrogating for rape, she was asking for it, right? We'll blame her rather than you. I mean, that's what minimization tactics are, is to sort of make it less serious and therefore easier for them But one of the things the police said was, a lot of these minimization things, like blaming the victim, don't look good on tape, and they don't play well to judges and juries, and so they tend to use them less frequently. But other kinds of techniques of neutralization, come right out of the criminal law. Like there's an insanity defense, and so the police, no kid wants to say, well, I was crazy, but I went crazy, or I got mad, and those are sort of emotional explanations for why I did what I did. Being intoxicated, they were often asked the kids, were you drinking or smoking, as a way of making you less responsible for what you did. Or they would blame the other kids. You were just an innocent bystander when these other kids got this bad idea to steal to rob the store. Or they just say it was a mistake. Kids that grow up, they spend their whole life growing up making mistakes. And so the cops would say, well, it was just a mistake that you robbed a lady. Or, that we can minimize the seriousness of the drive-by shooting. Well, they didn't actually hit the guy. So it's really, it's just a unlawful discharge of a firearm in the city limits. And the juvenile court itself is a kind of a minimization tactic. Police would frequently refer to the fact that juvenile courts are here to help you, not to punish you, as a way of kind of minimizing the seriousness of what the kids did. So then I looked at how do the kids respond to these kinds of maximization and minimization tactics. And table 5, sort of summarizes the kids' responses. And I was categorizing the responses into sort of 3 categories of a confession, an admission, or a denial. And a confession is where you give them facts covering every element of the offense. An admission is where you make an admission that will have some evidentiary value. Like, I didn't rob the store, I was just driving the car that the guys got into afterward. Or, I went into the house with the other guys to commit the burglary, but I didn't actually take anything myself. They don't know the law of accessorial liability. And the fact that whether you're the driver or the shooter, you're still guilty of the same crime. And then, there was about 10% of the kids who just kept denying it. I don't know what you're talking about, I wasn't there. So when I looked at how did the kids respond, 58.6% of the kids confessed, which was, I thought, high, but in the research coming out of the United Kingdom, the majority of suspects, both juveniles and adults, confess, and they usually do it pretty close to the beginning of the interrogation. An additional 29.8% of kids admitted some degree of criminal involvement. And so I have almost 90% of the kids in the interrogation room incriminating themselves to some degree. And, I thought, wow. But then, you go back to the literature, and it turns out in Richard Leo's work in Oakland, 3/4 of the adults confessed. In the Yale study, 2/3 of the adults confessed. In the UK, 3/4 of suspects confessed. Once they get you in there, you're pretty, as I said to my wife, these people are professionals. Don't do this at home. They really do know what they're doing. There were about 12% of the kids who denied any involvement. And when they did, the police would use a few more maximization tactics. But, once they saw that the kid wasn't going to give them anything, they'd say, okay, that's your story and you're stuck with it, and that's what the prosecutors and the judges are going to have. One of the variables that criminologists always focus on in dealing with cops and kids is attitude. And so one of the things I was looking at is, well, what are kids' attitudes like in the interrogation room, and how do those attitudes affect their responses to police? And how does that affect justice system processing? And when I asked the guy, what are these kids like? And they say, most of them are pretty cooperative. They're scared. About 1/3 of the cops use the same expression to describe kids in the interrogation room: deer in the headlights. I mean, these are kids who are just, they're literally frozen with the prospect of interrogation. So in the police reports, the police record kids' demeanor and attitude. They have a little box that they fill out. And so based on my sort of assessments of listening to or reading the tapes and the police characterizations of the kids, I would characterize them as either cooperative or resistant. And not surprisingly, the vast majority of juveniles who were cooperative also confessed. And about 43% of the kids who were resistant, the police didn't get anything from them. But again, it's important to emphasize, the vast majority cooperated and cooperated to their disadvantage. One of the things I wanted to know, and again, sort of when you do a piece of research that nobody's done before, there's just so many interesting questions. One of the questions I had was simply, well, apart from getting a statement, what else do police get when they question suspects? Do they get new evidence that wasn't already in the police reports at the time they questioned the kids? And in 18.2% of cases, they actually got something that they didn't have before. They would get a lead to where to recover physical evidence, or they'd get the name of another participant, or did you talk to anybody else about this, or they'd get some additional witnesses. But 18% seemed like a sort of a low number. And I asked the cops, well, why do you have such low yield? And part of it was, and they referred continually to the pressure of their workloads. We just don't have a lot of time to sit around and hold these kids' hands. And so, once we get our statement, we move on to the next file. Another important thing I found was I looked at what was the date of the offense and then what was the date of the interrogation. And 70% of these interrogations took place within less than 24 hours of the crime. Which to me means they really caught these kids in the act. You catch a kid in a stolen car, there's not a lot of, or you catch a kid coming out carrying stolen goods, so that in lots of the cases they didn't have to work them hard because they already had good, strong cases. I mean, I worked as a prosecutor in my youth, and as I was evaluating these files, it seemed to me that in 2/3 of the cases they didn't need to talk to them at all. They had more than enough evidence. But they also said, the county attorneys put a lot of pressure on us to question these suspects. The last table 6, I want to talk about, because that's, I think, one of the most important things I found. When we look at the literature on false confessions, it takes a long time to elicit a false confession. 85% of the false confessions took at least 6 hours, and about a third of them took 12 to 24 hours, and another third took 24 to 36 hours. I mean, it takes a long time to really wear somebody down to the point that they will falsely incriminate themselves. By contrast, what I found, 3/4 of these interrogations took 15 minutes or less. 90% took a half an hour or less. And, one of the things I conclude is, these kinds of brief interrogations are not likely to elicit false confessions. But again, I was sort of shocked by how short they were until I went back to the other research, and again, the Yale-New Haven study reported only 15% of interrogations took longer than an hour. Leo reported only a quarter of his took longer than an hour. Some research in Utah said only 13% took longer than 30 minutes. The UK stuff also said it only takes 15 minutes, 30 minutes. That 95% of the tape interrogations analyzed in the UK were concluded in less than an hour. And even the Inbow and Reed book itself says any reasonably competent interrogation would take longer than 4 hours. But even 4 hours is much, much longer than what routine interrogations look like. And I asked the cops again, how long does an interrogation take? And they say, 15 minutes, 10 to 20 minutes, less than 15, 10 to 15. Again, they were really corroborating that my finding that this is really short. It really is short. And that was sort of the reality of their experience. There were some interesting relationships between length of interrogation and types of crimes. Crimes that involve physical evidence, whether it's a burglary or a stolen car or something like a drug crime, because they have physical evidence with which they can confront the kid, those are going to produce short interrogations. The other and really important finding was I looked at cases involving guns versus not guns. Whether it was a gun that was used in an assault or in a robbery, or whether it was a gun that was stolen in the course of a burglary, and gun cases. Twice as many of them took longer than a half an hour compared with the other kinds of cases. And gun cases from the police are really serious crimes. They would question the kids for longer, they would use more tactics, they were really interested in recovering the guns. I actually had one tape in which the kid agreed to lead the police to where the gun was, and so I've got the whole squad, the tape is running in the squad car the whole time they're driving, to where the kid had hidden the gun. And I only had 2 cases that raised constitutional issues, and both of those were cases involving police efforts to recover guns. Guns also for the police were an indicator of gang involvement, and so that was another thing that made these more serious crimes and therefore encouraged the police to work harder. So let me talk a little bit about the policy implications that follow from this. In theory, Packer's due process model, says we have an adversarial system with procedural safeguards. In reality, we have a crime control inquisitorial system of justice in which the real trial takes place in the interrogation room. Once the person confesses, it leads inexorably to a guilty plea, which is exactly what Packer's crime control model described. Once you've confessed, prosecutors will charge you at higher levels, they'll offer you less in the way of charge reduction, they'll set higher bail, and so this interrogation really fits into the much larger frame of justice administration. One of the things that struck me was how few motions to suppress confessions were filed. And I attributed that to the fact that all of these interrogations are on the record. Once it's on the record, a couple of observations. One is because the police knew they were interrogating on the record, they were very professional. They followed Miranda, they went through it, they did exactly what they were supposed to do. There was no ambiguity about whether or not a kid waived their right. And then there was no ambiguity about the fact that they confessed, and so all the defense lawyers were really doing was arguing about disposition. So these scales tapes, really enabled the police in Minnesota to conduct an inquisitorial justice system, but an inquisitorial system on the record, so that we could refute what happened. And I'm sort of emphasizing this during the Q&A. We can talk a little bit about body cams. Because these recordings really have helped clean up what happens in the interrogation room, and my expectation is that body cams will do the same. So policies. Miranda was decided in order to bolster the adversarial process. The Supreme Court, felt, well, we can empower defendants and that will assure greater equality between the individual and the state. Miranda is the police officer's best friend. It only comes into place after a suspect has been isolated and subject to the inherently coercive pressures of custodial interrogation. It requires only shallow understanding. That is to say, do you know what the words mean? You don't have to know anything about the consequences of a waiver or whether your victim is alive or dead. All you have to do is understand the warning. And so rather than being a protection for defendants, it's really a window of opportunity for police. It gives them a 36 to 48-hour window in which the only protection is that which a very resourceful defendant can bring to bear, which is why 80% of adults and 90% of juveniles waive their rights and are then subject to this interrogation process. Miranda is especially problematic for the younger kids. As I said earlier, there's sort of this line between 16 and older adolescents and 15 and younger adolescents. And at least with respect to the younger kids, they just don't understand the warnings at all. They don't understand it. They are disproportionately overrepresented in the populations that give false confessions. They're especially vulnerable and susceptible to the kind of manipulations. They're more inclined, adolescents and the younger ones especially, are more inclined to comply with authority, to tell the police what they think the police want to hear. And again, because of brain and impulsivity, they're just trying to figure out what is the best way I can get out of here, right? What's the best way I can get out of here? And the best way to get out of here is to tell them what they want to hear. Similarly, as I referred earlier to the Reed training and to police training in general, they are not trained to differentiate between adolescents and adults. You know, and in some way, and they question black kids and white kids the same, they question boys and girls the same, they're trained in one method and they use it for everybody, and it pretty much works for everybody. But the kinds of tactics that are designed for adults can be especially problematic when we start deploying them against younger kids. Now, when I refer to the Supreme Court decisions, Haley, Gallegos, Galt, Fair, Alvarado, JDB, the Supreme Court drew a functional line. It excluded confessions taken from kids 15 and younger, and it admitted confessions from kids 16 and older. And that sort of de facto line the court constructed without benefit of the research on developmental psychology really tracks very closely the line that I've been describing in terms of kids' competence. So the first thing I say is, for the younger kids, mandatory non-waivable counsel. I mean, the young kids have to have a lawyer in the interrogation room. You know, and obviously, you know, if you give kids a lawyer in the interrogation room, that's going to have an impact on police interrogation. But on the other hand, you know, to give a kid a warning that they don't understand and then to exploit their vulnerability to their disadvantage, you know, offends my sense of what fundamental fairness would entail. Second is to focus on lengths of interrogation. You know, as I said earlier, most of the false confessions, it takes 6 hours or longer in order to elicit them, and youthfulness exacerbates the problem of false confessions. When we look at the false, you know, we see all these DNA exonerations and people, you know, wrongful convictions, and in about 25% of the wrongful convictions, there will have been a false confession. But then when you look at the age skew for false confessors, you know, 42% of the false confessions come from kids in these relatively limited samples of false confessions. And they're skewed younger, so that the younger kids are even more likely to confess falsely than the 16 and 17-year-olds. So as we think about the relationship between time and interrogation, you know, I think given that routine interrogation is really pretty short, and the interrogations that produce false confessions are really pretty long, we should have sort of a sliding scale presumption of coercion once an interrogation starts taking more than a few hours. And finally, you know, I come back to the idea of recording, and I've been giving this talk in several states and before several legislatures around the country, because it seems to me that the absolute no-brainer of criminal justice reform is mandatory recording of everything that takes place between a suspect and the police. Simply being on the record will reduce coercion. It will encourage police to not use certain kinds of problematic tactics. It gives us an objective record, apart from the swearing contest between a suspect and the police, that gives judges an independent basis on which to evaluate what actually happened. It will also improve the quality of police investigation, because police don't have to sit there and take notes. They can just listen and listen more closely. They can go back to recordings later to see if there were things that you know, that provided leads that they didn't hear at the time. It also enables us to determine whether or not there's been evidentiary contamination, because many of the false confession cases, you know, involve information that only the guilty person would know. But in many of the false confessions, the reason the suspect knows it is because the police told them, and then they sort of repeat it back. And so mandatory recording would enable us to detect that kind of contamination effect. You know, recording strengthens prosecutors' hands. And it also enables defense lawyers to have a better sense of what happened than what their client can tell them about a stressful event that took place, you know, weeks or months earlier. And as I said, recording also, at least in Minnesota, sort of eliminated suppression hearings, which means we save a lot of money. We don't have to have police and defense lawyers and prosecutors sitting in a courtroom to talk about whether or not they gave a Miranda warning or the like. So, you know, but only full recording. That is to say, every single interaction between a suspect and police. Not just a final narrative in which we've already beaten him up a half a dozen ways and then he gives us a confession, but you have to have the entire process on the record. Because as I said earlier, you know, the Supreme Court says we have an adversarial process. And my argument here is we really have a crime control model. It's an inquisitorial system. But every defendant doesn't need a trial. But we do need some way to assure the reliability of our inquisitorial system, and a recording requirement puts no burden on the justice system, and it enables us to administer an inquisitorial criminal justice system on the record. Thank you.
Professor Reinke will begin with his comments.
Let me set the microphone for you.
The microphone would be best.
Thank you, Barry. Enjoyed the talk very much. So, in my comments here, this is difficult to serve as a panelist, which I interpret as being in some ways a critic, not in the sense of being negative towards anything, but maybe challenging the author a little bit. And it's challenging here for two reasons. Number one, I agree with almost all of what Professor Feld has to say. And number two to that, and most of what I know about juvenile justice comes from Professor Feld. So I'm kind of at a disadvantage in terms of trying to critique. So what I'd like to do here, and I hope you'll bear with me, is step out of my own shoes and try to play the role of somebody who might be skeptical of this work at the outset. And then my goal here is to provide maybe some critical perspective, and then give Professor Feld the opportunity to respond and to elaborate on some of what he talked about in his presentation. So I'm going to step into the role of somebody I imagine might want to challenge a few ideas. So I'm going to imagine myself as the seasoned prosecutor who decided to leave office and teach at a law school for the remaining part of his career. And so my comments might go something like this. Professor Feld, I agree with you about one thing. It was a great book. It was very fairly written. Enjoyed it. But I'm not convinced that your policy recommendations follow directly from the evidence. And I'm not sure that the crime control model really is what's depicted in the book, at least not more than the due process model. Let me start with that point. So Professor Feld mentioned the crime control and due process models, and that's kind of a staple of criminal justice, usually in the first week of class. It goes back to a 1964 law review article by Stanford University Professor Herbert Packer. It's kind of a classic, in which he says, we've oscillated throughout U.S. history between two models of the justice process. The crime control model, in which the goal is to keep us safe, protect us from crime. Occasionally, that means an innocent person might be convicted, but that's okay if it means that if we want to exercise our liberty, we have to feel safe to do so. Emphasizes the early stages of the process, such as interrogation, and it necessitates a lot of trust in the police. And that's juxtaposed against the due process model, which emphasizes fair procedures. And think of the criminal justice system as an obstacle course that privileges individual rights along the way. Emphasizes trials over pleas, and is distrustful of the pleas. And so when I read the book, which I highly recommend, it is a very good book. Step out of my law professor, prosecutor role, and Brian King for a moment. It is a very good book. But I read the chapters thinking that the police actually exhibited a pretty high degree of professionalism. In some cases, they went at extra lengths to make sure it wasn't just signing a form, but in some cases actually said, now can you read, I think this was, I don't know if was this correct, or I have that right, in which one of them said, now tell me, what does the right to remain silent mean to you? And the person being interrogated indeed was able to, say it back and in his own words, and it made sense. The interrogations were short, very short, as Professor Feld alluded to. There was little evidence of wrongful conviction. They were all videotaped, and only 3 of the 307 cases involved a potential constitutional issue. I'll give you last word on that in case I misstated. In other words, we think about the ideal type of the due process model, at least as I understand it, is the Warren Court of the 1960s and the due process revolution, where we get Miranda and where we get Mapp versus Ohio and many of the rights that we have today in criminal procedure. And I see a lot of that in action in this book and in what happens in the interrogation room. And so I'm wondering, so my first critique as a law professor was, isn't there a lot of due process to accompany the crime control? Second is the policy recommendations, 2 of which, and if I'm the prosecutor here, former prosecutor, I would say 2 of which, no problem, we agree entirely. Length, we've got to cap it, because nobody wants a wrongful conviction, and we've got to make sure that people don't get ground down to just confessing to get out of there. Second, the recording, no problem there. The idea of a mandatory attorney, though, is maybe one that I would ask Professor Feld to say a bit more about. And really this comes down to practicality. Is this feasible? Not in the criminal justice system that I would like to see. We could go on and on beyond mandatory attorney there, but in the one that actually exists. The headline, or an op-ed headline and title, I should say, in today's New York Times is "No Lawyers to Spare for New Orleans, for the poor in New Orleans." We don't have enough attorneys. We simply don't have enough attorneys. I wonder if you could speak to the resource constraints and what that means, and why not, maybe instead of an attorney, what about having a parent as somebody who could be there as mandatory instead of an attorney? Of course, they always have the right to the attorney. And then finally, my third point would be, as a potential critic here, would be, are there unintended consequences? And so, one of the findings from the book that was not mentioned in the talk is that those who, correct me if I'm wrong, please, Barry, those who that invoked their rights had slightly more punitive consequences as a result. The penalty was a little, and this, I couldn't help but think about a related issue in criminal justice, plea bargaining. There's what some people call the trial tax. If you go to trial, you may be found not guilty, but if you're found guilty, you're going to get a stiffer penalty. But the trial tax can also be understood as a plea discount. If you plead, you might get, so I'm on a plea bargaining panel right now, so be careful what you ask for, because if there are more trials, we can end up with more punishment. And so I'm wondering if there's an unintended consequence where if they do lawyer up, if they don't confess, and if the evidence is strong enough to find these children guilty, do they risk getting more severe penalties as a consequence, and could that be an unintended consequence? So, now I get to step back and be Ryan King and say, I'm not sure I believe everything I just said, but I can't imagine somebody raising those issues, and I wonder after Linda speaks if maybe you could speak to a few of those. So thank you, Barry, I enjoyed the talk.
Thank you too, Professor, I enjoyed the talk as well. So I'm going to take this from a little bit different angle, from a practitioner standpoint. I think one of the things that we have to do when we work for state government in particular, because frankly, I work for all of you. I don't just work for Governor Kasich, I work for all the taxpayers in the state of Ohio. It is imperative that we listen to research, that we apply research, and that we make decisions, both policy-wise and financially, based on what we know through research. So just to give you a little bit of background, so we are the state agency that incarcerates youth. We hold youth from the age of 12 years old, that's the youngest, up to 21 years old. We have 3 facilities, about 475 youth incarcerated right now. The average age, and most people don't know this, is about 17 and a half years old. How many people thought it was a lot younger? No? Yes, some people? Yeah, most people don't realize that. It's about 17 and a half, and then our average age on parole, and everybody in Ohio comes out on parole, is actually 18 and a half. So that's kind of interesting too, and we're learning, again, through research, that we have to employ different strategies and not stop those strategies just because a youth turns 18. We know through some brain development research that there's all kinds of issues and tactics that we have to employ really up to 24, 26 years old before especially male brains are fully developed. So, you know, again, I'm thrilled to be here because we have to marry that practice with the research and the evidence. Another thing I wanted to talk about is what we've learned from Professor Feld specifically and through some other researchers. We're in a unique position because our youth are already incarcerated. So they're in what could be perceived as even a more vulnerable place, a place where there's authority all around, a place where parents aren't always available. So we used to employ some of the tactics that the professor described when we were investigating incidents in our facilities. And there's really three kinds of incidents. The one raises to the level of what is a felony or crime, so the State Highway Patrol would be brought in for those. The next level is a high-level internal rule infraction, such as an accusation of sexual assault, an accusation of use of force, and then the lowest level is something we call just a general rule infraction. So at each of those levels, what we found is we were interrogating youth for hours upon hours. We were getting confused information, we were getting sometimes false information, and it actually made it more difficult to make sense of actually what happened in any of those incidents. Now at the highest level with the State Highway Patrol, if they're being charged with a felony, the Miranda rights kicks in and all of that. But that other two levels, they don't. So we found that oftentimes our questions were forceful in nature, certainly an interrogation of sorts, and it just wasn't good for our youth, and it wasn't really getting us the information that we needed. So how we changed that process is for both that mid and that low level, we have what we call youth advocates in each of our facilities. So a youth is never questioned by our chief inspector, which investigates that middle level, or even a staff person in our facility without that youth advocate being present. And why we found that so important is just to help the youth understand, or do you know what this means? Do you know what you're being accused of? Do you know the consequences? And then we also found that during our investigation process, we shifted to more of a conversation, and it was shorter in, or it is shorter in nature, and we found that we got a lot more truthful information. The young people were more comfortable going through that process. And it's amazing with our kids and anybody who has teenagers like me, if you open that kind of environment, I mean, they'll just talk their little hearts out and you'll get a lot of information. The other piece I want to mention about our kids is we've done a good job in Ohio of diverting the low-level felons, the lower-risk kids to community-based programs. So a lot of people say, well, gee, Linda, you've got the worst of the worst kids. You've got the hardcore. What I would challenge everybody to think about that a little bit differently is we have the kids with the highest needs who've been subject to the most risky environments. They've been exposed to trauma. Half of our kids, or a little bit over half, are on a mental health caseload. Little over half have individual employment or individual education plans, the IEPs through the education system. We have quite a few kids on psychotropic medications. So these are kids that are high need and high risk, but we also don't want to re-traumatize them by any of our interview tactics because that's really easy to do. For example, we shifted to a language of we take drug tests and urine screens to make sure our kids in our institution and on parole aren't using drugs. Well, we shifted to a language instead of saying, you're dirty or your urine's dirty. Because what we found is that really triggered some kids and their backgrounds, and it was more of, frankly, an abusive kind of language. So we talk about the drug screens, either use the term positive or what it tested for, and then investigating the case from there. So again, and I'll certainly be open for questions, but I just wanted to thank the professor and other researchers and folks at this university for really providing the research in juvenile justice that's extremely valuable to us folks who are practicing it, and it's incumbent upon us to certainly implement those practices and continue to see what the latest research is and keep up on it with the cutting edge information out there. So thank you.
So trying to respond to both of you, you've sort of invented investigative interviewing in the institutions, and several of the interrogations I had also involved, kids either in group homes or institutions, and it was typically, a sexual offense, in which, but it was felony level, serious stuff. And what you described, that when you use these softer tactics, you in fact get more and more reliable, is exactly what the UK research has found. And it's one of the reasons why, I've been working with Innocence Project people here around the country to try to shift the tactics police use to this more investigative interviewing. You referred to your youth advocates to bolster kids, and Ryan asked about, the availability of parents, and there are like 10 or 12 states that require parental presence at a kid's interrogation. And even though Minnesota law does not require it, about 25 of my interrogations were ones in which parents were present. And in 24 out of those 25, the parents either did nothing or were affirmatively harmful to their kids' cases. Because parents, we socialize our children to tell the truth. And the worst thing that can happen to a person in the interrogation room is to tell the truth. And so sort of normal parental socialization is going to almost invariably work against the kids' interests. And so, at some point I will spin off an article that talks about why parents are a hazard to their kids, and try to drive a nail through that coffin. If you want to protect kids, there's only one protection, and that's lawyers. The Supreme Court in Fair versus Michael C., where the kid had said, I want to talk to my probation officer, and part of what the court was looking at is a request for a probation officer, the equivalent of an invocation of counsel or an invocation of a parent, and the court said, no. If you want to have a lawyer, you have to ask for them explicitly. And the court went on at great length about lawyers are the greatest things in sliced bread, and especially in the justice system, it is true. Because there's research on what do parents know, and parents don't know much more than what the kids do, and they certainly don't know about the kinds of tactics that police will use. They don't know that police can lie to suspects. And so, parents are really, in some ways, going to put their kids at a disadvantage. And so, I come back to Ryan's question about the crime control versus due process model, and my recommendation that, that the younger kids should have lawyers. I've been dealing with this delivery of legal services in juvenile courts for about 3 decades. And, it was actually much earlier in my career when I was trying to fill in some footnotes on kids' waivers and Miranda rights that I just sort of went off and said, well, what do we know about delivery of legal services in juvenile courts? And, a book and 5 articles later, what I discovered was in 3 of the 6 states for which we had data, the majority of kids tried in juvenile courts never saw a lawyer. In Minnesota, 1/3 of the kids who were removed from their homes and 1/4 of the kids in the training schools never saw a lawyer. So I 100% agree with you that there are lots of issues about feasibility and resources and practicality, but that really gets us to the heart of justice. Because to give a kid a warning they don't understand and then take advantage of it because they don't understand it, offends my sense of justice. To run people through the justice system without lawyers because they've waived their right to counsel under this knowing, intelligent, voluntary that I described, that they don't know, and which the judges themselves are pressuring them to waive. Now, in my writing about lawyers, one of the things that shows up very interestingly is that kids who have lawyers receive more severe sentences in juvenile courts than kids who do not have lawyers. It is the juvenile equivalent of the trial penalty that we see in the plea bargaining context. And when I did my right to counsel research, there have been 6 dissertations replicating my stuff in 6 different states, and they all show the presence of a lawyer is an aggravating factor in sentencing for kids. So you say, well, why would that be? one answer, well, lawyers are incompetent. Or if not incompetent, they are working in justice systems where they are carrying caseloads 4 and 5 and 6 times heavier than what the recommended caseloads for lawyers should be. Or it may be that judges are deciding early in the process what their eventual disposition is going to be, and then if they think they're going to make an out-of-home placement, then they'll appoint a lawyer for a kid. But then you ask yourself, well, how does a judge know at the time of arraignment what a kid's sentence is going to be down the road? And the answer is there's a lot of informal conversations that go on that also undermine the legitimacy of justice. And finally, I think judges may impose a lawyer penalty in the same way that we see a trial penalty. But that really does go to justice. We tell you you have a right to a lawyer. You have a constitutional right. Let's exercise it. There's no point in telling, and then we also have a societal obligation to make sure that you run a justice system that's just, which means we have to provide lawyers. When I give this kind of conversation, when I testify at legislatures, the legislators, oh, Phil, this is just a full employment program for your law students. And it's true, my law students need jobs. But it is also true that we have a terrible mismatch between the availability of lawyers. I got lots of kids rattling cups out on the street. A mismatch between the need for legal services, and especially in the justice system, and the availability of competent, compensated, sufficiently resourced lawyers to do the job. But one of the nice things about being an academic is I don't have to deal with practicality, and I don't have to deal with appropriations. I just have to deal with justice. And in my mind, this is just like recording. Giving defendants and lawyers is another no-brainer.
Okay, so it's time to open up the floor for questions. We have about 25 minutes. So please direct your questions to Professor Feld or our panelists.
So I run the juvenile law clinic over at the law school on campus.
Great.
Yeah, right. So I deal with the practicalities. And so one point that I want to ask about too is sort of in the lawyer tax situation. The other thing is that lawyers are not trained to be developmental experts with teenagers. And so when you talk about that impulsivity of kids making decisions about I want to get out of here, I want to get out of here, maybe the reason you're not seeing a lot of those motions to suppress or they're not being litigated is because your client is saying, I want to deal with this, just get me out, just make the deal so I can get out of here. And I run into kids where I have good cases to litigate and I can't get them to hang on because they're sitting in detention while they're waiting.
Right. Yeah, I ran a juvenile clinic back in the beginning of my career, but it's just too labor intensive. Talk about we need lawyers. This is all part of as we think about juvenile justice. Why are those kids in detention? And Juvenile Detention Alternative Initiative. Do you have JDA? Yeah. Yeah, I mean, we've been trying to get these kids out of detention exactly because it's one of those things that creates those kinds of pressures to give up good cases or defensible cases. It's like plea bargaining. It's in everybody's short-term interest and nobody's long-term interest to run a justice system like that. You're stuck in the middle of it. One thing I want to talk about, though, you mentioned brains. There's a lot of excitement about adolescent brains and synaptic pruning and myelination and the way the prefrontal cortex talks to the limbic system. I mean, I've written some stuff with neuroscientists, and those pictures are just dazzling. It's another one of those areas where we've got this really, really exciting research, and we have absolutely no idea what to do with it. Knowing that adolescent brains in the aggregate are different from adult brains in the aggregate doesn't tell us anything about what to do with this particular kid. And we also don't have any real linkage between brain development and actual behavior. And the importance of that is that even though all adolescents are on the age crime curve, and they all have similarly unmyelinated, unpruned brains, most of the kids with bad brains don't do bad behavior, or at least criminal behavior. So the brain itself doesn't tell us anything about this particular kid when we're trying to deal with them. So that's just.
In an ideal world, say you increase the number of lawyers available for defendants, and say instead of 11%, now we have 50, 60, 70% of defendants having a lawyer. Do you think that potentially can minimize the lawyer penalty that we're seeing so far?
Yeah, one of the nice things, you know, it's sort of, when I've done my lawyer research and I've done, you know, looked at variables lots of different ways, when you have a full representation system, the lawyer penalty washes out because there's no variation on that variable. You know, if everybody has a lawyer, then you can't compare the sentences of the kids with lawyers and without lawyers. But there are some states, you know, California, New York, some other jurisdictions that really do run full representation systems. If you're interested in a lawyer, the National Juvenile Defender Center, NJD, the National Juvenile Defender Center.org, you know, has been doing state-by-state assessments of deliveries of legal services, and the kinds of stuff that I was reporting back in the 80s and 90s, you know, really provided the impetus both for OJJDP when that was reauthorized to provide funding to look at these questions of lawyering and ultimately to improve the quality of lawyering. And the National Juvenile Defender Center has been looking at delivery of legal services. They've now done studies in about 20 states, and what they keep coming back with is, you know, like in 19 out of the 20 states they've visited so far, there are really very serious problems about just getting access to counsel and having the resources for lawyers to work like lawyers. But, you know, if you have full representation, you know, it's the same thing. If everybody went to trial, we wouldn't have trial penalty. And, you know, and it's the same thing for representation. But, you know, the system's really resistant. You know, and it's especially resistant to things that are going to come up the works. And, you know, one of the nice things about lawyers is they can come up the works.
Going back to your implication points, it's the point right after crime control and due process. I thought I heard you say that those people who gave a confession had less plea bargaining and did not get as good a sentence.
Yeah, I mean, that's what the research literature in the plea bargaining area, you know, and Ryan's your expert on plea bargaining, but, you know, basically defendants who confess are at a negotiating disadvantage with respect to prosecutors' willingness to give them a break.
Okay, that wasn't specifically from your own research.
No, that wasn't from this.
Okay.
You know, Ryan did advert to one thing, which is that the kids who invoked their rights, you know, were marginally more likely to end up incarcerated than the kids who didn't. But I didn't have a big enough N for me to be able to tease out whether, because he also recalled that the kids with prior felonies were more likely to invoke. So I couldn't tell whether the kids who were getting these more severe sentences were getting the more severe sentences because they invoked or because they also already had more extensive prior records, which led them to invoke.
So you say so the prior record is the only thing that differentiates those who invoke from those who do not. And I'm looking at the characteristics. About half the kids are kids of some kind of color. And we often think that those kids should be at a disadvantage in the system, but they are not, according to what you've presented. So do you think that, but they are a disproportionate share of the kids.
Especially in Minnesota.
Yeah, especially in Minnesota. So do you think that this is all about the recording of them, or is it just police are nicer, or the same, or less discriminatory in Minnesota, or is it something about process?
Yeah, you know, as you know, race has been one of the variables that's defined my career. And so when I started doing this, I was really interested to see whether disproportionate minority confinement started in the interrogation room. And so, you know, in the book, I didn't have time to talk about it today, but in the book I look at police interrogation by race and police interrogation by gender. And what I found was there was no statistically significant difference in rates of waiver by black kids versus white kids, by boys versus girls. You know, there were marginal difference, you know, a couple of percentage points differences, but nothing of any particular consequence. A couple of observations that don't rise to statistical significance. It seemed to me that police did not have quite as strong cases against the black kids as the white kids. And so they tended to use a few more maximization tactics with the black kids than the white kids. But you know, these are really sort of on the margin. And again, I think, you know, your suggestion that it was really recording, you know, that they knew, they were on the record, they knew that if the case went to trial, a judge and a jury would listen to what they did. And so, you know, the police were really pretty scrupulous. I mean, I was surprised, the same thing with the girls. You know, girls and boys waived at the same rates. Cops may have questioned the boys a little harder than the girls, but that's because when girls were involved in felony level delinquency, you know, they were more likely to be driving the car than robbing the store, or they had a more peripheral involvement, and so they were a little more ready to cooperate. But, you know, sort of my overall conclusion is police are trained to question people one way and they question everybody the same way. So at least in this, I mean, given my data, you know, I did not see the beginning of DMC in the interrogation room.
Can I follow up briefly on that? So if it is the recording that you think is a substantial difference between all of it, I think earlier at some point you mentioned, or maybe it's during the talk, body cameras.
Yeah.
Would you recommend it? Do you think that would make a difference?
Absolutely. You know, I was back in the mid-'70s. I was on a commission, I mean, I kept on all these commissions all the time. You know, they always look for a law professor to give legitimacy. Now, I was on one of these commissions back in the mid-'70s in Minneapolis, dealing with police minority community relations, and you know, and when we were looking at it, we discovered that there had in fact been 3 prior commissions in the 60s after we had the riots in Minneapolis dealing with police minority community relations. And one of the things we proposed in a report that we issued like in 1975 or 76 was mandatory recording. That every time a police officer approached a citizen, they should have a recording of it. And you know, now 40 years later and technologically later, we are at that point. I have absolutely no doubt that body cams are going to clean up policing. You know, at least the stuff in the alleys and the lumpen legal kind of policing.
We have time for a couple more questions.
So how many of you were surprised at how short interrogations are? How many of you were surprised at how benign interrogation is? I mean, it's really like, you know, sort of as I describe this work, it's so different from what we see on television and in the movies, and you know, sort of what we are led to believe versus, you know, what actually happens. And, you know, and that's one of the wonderful things about, you know, being a sociologist or a criminologist is you get to go out there and describe reality, and there's a great difference between, you know, what we think we know and what's actually playing out there.
Fire warning.
Well, let's please join me in thanking our speaker and our 2 wonderful panelists.